Legal fees are an important component of the mortgage foreclosure equation, and the standard rule is that a plaintiff, a foreclosing plaintiff, is entitled to recompense for reasonable legal fees so long as the contract, which is the mortgage, so provides. So they are a typical component of the foreclosure action. How much is a different issue, but that they are available to a foreclosing plaintiff is very well accepted. The American rule on legal fees being that the parties are responsible for their own legal fees unless statute or contract provides otherwise, and in the case of legal fees to the lender, it is the contract which usually provides otherwise. Which leads to the question, which is current now, and it's because of new legislation, as to whether a borrower is somehow entitled to legal fee payment. The answer, with certain statutory exceptions we don't need to mention here, has been no. But the mortgage crisis of recent years has led the legislature to pass a new statute which will provide legal fees to a borrower in a situation, this is in a residential situation, where the mortgage provides legal fees to the lender but is silent, as it would be, as to the borrower. The contract, the mortgage, needs to be read pursuant to this statute to award legal fees to a successful borrower. The question then becomes, what is an indication of success or victory on the part of a borrower? If a lender were to bring a foreclosure action in error, the borrower really was not in default, and the lender never should have begun a foreclosure action. That would certainly be unfortunate and abusive, and in that case, if a borrower defeated the foreclosure, as one would expect they would, then an award of legal fees to the borrower, who had to engage an attorney to fight off this unfortunate and unfounded assault, is appropriate. But what happens if the borrower argues that process service was not correct, which can be a very elusive subject? And what if the court determines that, yes, the borrower was not properly served and thereby dismisses the action? Is that the kind of victory on the borrower's part which should yield legal fees to it? After all, we haven't determined that the borrower wasn't in default. That's not an issue. They may very well have been in default. It's just some mechanical error. The answer to this question, and this is the disturbing area, is that the statute awarding legal fees to a successful borrower is based upon a like statute coming from the realm of landlord and tenant cases. And in those actions, it has to have been a substantive defense by the borrower which brought about the victory, which bodes well for lenders in this situation. That said, however, the zeal to protect borrowers nowadays is so great that it gives pause to lenders and raises a possible concern that will be disposed of one way or another by case law as we encounter it. Statute is too new for the moment, and let's see where the courts go on that subject.